Brief facts of the case. The petitioner happens to be around age 25 years old. She is hailing from an agricultural family belonging from Manipur. She was residing at Delhi at the time of institution of this present petition, writ petition, present SLP under the Supreme Court. She was in living relationship with her partner. She had consensual sex. Out of that, she became pregnant. She wants to terminate her pregnancy beyond 20 weeks, and that is why the problem has come up. So, if it is within 20 weeks, she could have terminated. But beyond 20 weeks, Rule 3B of MTP rules doesn't explicitly allow unmarried girls to terminate her pregnancy. Because of that, she has to approach the Delhi High Court as well as the Honorable Supreme Court for getting justice. That is for terminating her pregnancy. This is the facts of the case. Then, issues. Strictly speaking, there is no issues, only submissions, and it is a cooperative litigation rather than there is no rival submissions. Both the counsel for petitioner as well as additional solicitor general Aishwarya Bhatia has cooperated in making a purposive interpretation so that medical rule 3B of MTP rules constitutionality is retained, because the court says it is an illustrative one rather than an exhaustive one. So instead of making it unconstitutional, they are giving an expansive interpretation to rule 3B. Therefore, it can accommodate the interest of the unmarried girls also by finding by adopting the purposive interpretation. This is very important. Then we go to the judgments. Judgment. The judgment has been divided into almost from A to I, that is 9 parts, addressing various issues including background, facts, access to barrier of safe and legal abortion, the plight of unmarried as well as married girls in getting abortion, the social stigma relating to having sex outside the wedlock, single problems faced by single mother, transgender, including commercial sex workers. All these things are addressed. Apart from that, the judgment also rightly makes it very clear that the right to reproductive health is part and parcel of dignity of life under Article 21, right to privacy under Article 21, and personal liberty under Article 21. It is also rightly tracing the relationship between the three, that is, interlinkage between dignity, privacy, and personal liberty. Apart from that, it is also rightly recognizes and enforces the directive principles of state policy, including right to health under Article 47. It also highlights the lack of adequate facilities in the in the rural areas, and huge inequalities in the access to safe and in the access to safe and legal abortion facility available in the urban as well as rural areas, by pointing out Article 38 Class 2, which talks about inequalities between various segments of the society. And lastly, it also talks about the legal obligations, international legal obligations arising out of various treaties, covenants to which India happens to be a party, so that the current MTP rules must be aligned with the aforestated treaty obligations of India arising out of various international treaties and obligations. Finally, the judgment makes a conclusion. So, this is the description about the judgment itself. Now we'll talk about some of the important aspects of the judgment. Um, this can also be treated as ratio decidendi. This judgment grants three important relief. One, it clearly recognizes right of unmarried women to get abortion up to 24 weeks. That's very important. So it says that there is no rational behind, um, there is no rational in treating married women and unmarried women on the right to abortion on different footings. Therefore, it equates them on one footing. Therefore, it makes both are entitled. That's very important. Next point, it also enhances the meaning of marital rape solely for the purposes of right to abortion under the MTP Act and MTP rules in conformity with Article 21. This is very important. The third one is that it also protects minor girls' interest. It clearly lays down that it clearly mandates the medical practitioners not to disclose the identity and details of the minors when they are coming for the termination of pregnancy, though there is a mandate under section 19.1, 19.2 of the POCSO Act, which means it applies the doctrine of reading down of the section 19 of POSCO Act. It says that you can give the report, but it is not necessary to disclose the identity of the minor and other things, so that the girl children may come forward for the safe and legal abortion rather than adopting the illegal route or clandestine route. So these are the three important uh, principles laid down under this judgment. One, unmarried girls are entitled in par with married girls in getting right to terminate their pregnancy. Two, marital rape is expanded for the purposes of availing termination of pregnancy under the MTP Act. Three, POCSO Act has been aligned as per the MTP Act. These are the three important principles laid down by the Supreme Court in this particular case is concerned. Now let us focus the rights addressed or the subject matter of the case. Next important heading. The case is addressing the rights of following women. One, unmarried women, single mother, widow, divorcee, all these things. Next, it also talks about minors, girl children below the age of 18. For that, it relies upon independent thought versus Union of India. Then, it also talks about transgender or other types of women. Their right to get termination of pregnancy is also addressed. It also talks about persons with disability, including intellectually disabled women and physical disability women or differently abled women. Apart from that, it also talks about the rights of CSW, commercial sex workers, for terminating their pregnancy. So these are all the important categories of women recognized. Apart from that, it also talks about in expanding the meaning of rule 3B, particularly G, talks about emergency situation, refugees, violence, sexual violence, and all other things. Therefore, it makes it very clear whatever it has been discussed, it is only an illustration, it's not exhaustive. So, whoever is put in a similar footing, they are also entitled to get remedies. and each case ought to be decided on its own rather than having a straight jacket formula. This is the ratio laid down under this particular case is concerned.